Hello, I'm Angela Princewell, and on this segment of Ask AP, I'm going to be answering a question around whether or not it matters if you're the first person to bring a court application. And in short, for the most part, it doesn't matter who brings the initial court application. And for those who don't know what a court application is, it's the paperwork that initiates a court process in a family law matter. So if you're married, it's the process by which you would ask for a divorce, equalization, and other issues that have a reason. For unmarried persons, the application is usually where would make any claims relating to property, if there's support issues, parenting issues, things like that, it all gets started in the initial court application. And so oftentimes there is concerns with our clients. They want to make sure that they're the first to start the application. And, getting this question today, it just, reminded me a lot about that. And for the most part, frankly, it doesn't matter. And it doesn't really matter who brings the application first. Now, the only advantage, and it could be a significant advantage to you with bringing an application, is if you want, is that you get a chance to reply. So the way the process works is party one brings the application, then the other party two, would call them answers, and then party one gets a chance to reply. Often the reply is generally abused because the reply is not supposed to be a chance for you to say, well, they're lying and this, and then reiterate the things you had said in your application. The reply really should just be replying to new claims made in the answer. And that's why generally it really doesn't matter who brings the application. So when a person makes an application and includes all the claims that they want, when you're if you're the party that has to answer, you get an opportunity to state every other claim that you want to make. So being a little bit more specific here, if someone brings an application, say asking for just equalization, for example, in your answer, you could respond to the equalization claim, but also make claims relating to, parenting, child support, spousal support. You're able to do that even if it's not you who brought the initial court application. Now, the reply is an opportunity for the person who brought the application to respond to those issues that you never raised or didn't say anything about. So sometimes, so most times it really doesn't matter, but there's times where people can, I'll say, quote unquote, maybe abuse the opportunity for a reply and kind of maybe hit home some points a little bit more. And there's also, strategic reasons. If you want to be silent on a particular claim and you want to see if the other party raises it, then maybe bringing an application, staying silent on those issues, seeing what the answer you get back entails. And if it's silent on the issues you never wanted to talk about, fantastic. But if it's not, then at least you get the opportunity to reply and deal with those issues. Um, Now, I have had, there was a concern with regards to, I guess I'll call it the aesthetics of it, right? So, this person asking this question is very concerned about how it looks, that they're not the one that brought the application, and they wanted to be clear that you know they they initiated the separation, and they want it to be clear. And frankly, it doesn't really matter in Ontario who separated first, but I can understand, from a personal perspective, maybe you wanted to be clear that you chose to put an end to the relationship, and that could be included in your answer. So if that's something that really, really matters to you for reasons that are definitely not legal, because it doesn't really matter from a strictly legal perspective. But for whatever reason, if you want that to be set out clearly in the records, then you can always do it in your answer. And, kind of, we do talk about backgrounds, and there you can explain that, I separated from X or Y on so and so day because of whatever, if that really matters to you. But if we're talking about from a very strict legal perspective, don't be too worried if you miss the opportunity to bring an application. If there's claims you want to make, you have a chance to make that claim, those claims in your answer. If there's a narrative that you want to make sure is on the record, you will get your opportunity to put all of that in. So yeah, for if you need to, if you have to answer to a claim, don't feel confined, don't feel as though the other person would get all they want, because the claim is really just an opportunity to put forward what they're asking. And you could just simply ask for it all to be dismissed, and then ask that the court make an order that is favorable to the claims you're making in your answer. So I hope you find that helpful, and until next time, it's bye for now.